Friday the 13th, and as Kelly reminded me, it is a full moon. So let us all have a great deal of caution today. And, really, I'm really excited because, it's great to talk about, what's going on with fair chance hiring and our role at the Department of Fair Employment and Housing. And we're also going to talk about fair housing. So this is a really, stuff I love to talk about. So I look forward to your questions. And, I'm just going to kick it off. So as you heard, I'm the Assistant Deputy Director of Education and Outreach, and I'm fairly new to DFEH. My prior life, I was a senior attorney at the Legal Aid Society in San Diego, where I ran a fair housing program, and we did a lot of stuff around race and unlawful discrimination. And so I kind of draw from that background to our discussion today. I'm going to just move forward here. Hold on here. Okay. Sorry, I'm having a little. Okay, here it is. No. Okay, here we go. Sorry, I couldn't change the slide. So anyhow, yes, we are DFEH, and we are the civil rights agency for the state. Often, when I go around, folks have never heard of us, and that's something that we're hoping to change because we're here for you. We have lawyers. We have 300 staff members. We investigate cases. We litigate, and we do outreach and education. So we are here to serve you, our fellow Californians here, to ensure that everyone's civil rights in California are respected. Now, really our mission, again, is that we cover discrimination kind of throughout all facets of life. A lot of what we do, and we're going to talk about here today, is our employment discrimination. We are the agency charged with enforcing the law when there is discrimination in the employment context. And then we also cover discrimination in the housing context. So where there is unlawful discrimination, the public can file complaints, or we can even initiate our own complaints and try to remedy the situation. And then we also deal with public accommodations. And what that means is basically we're the folks where if someone tries to go to a restaurant or wherever and they're told that they can't be served, or we won't serve you, or you're not allowed here because of either your race, gender identity, sexual orientation, go down the list, that's going to be unlawful and a problem. And eventually we at DFPH would bring that case. And then we also cover hate violence. So this is folks who are, someone's burning a cross, someone's threatening violence based on who you are, your race, your gender, your religion, your national origin. We would be the agency to get involved with that. On the civil side, we don't bring criminal charges. We don't do any kind of criminal law here at DFEH, but in a hate violence situation, Department of Justice would be involved, but we handle the civil side. So if someone was damaged or injured because of the hate violence, we would be involved. And unfortunately, we receive those cases, whether it be slurs written across people's doors and cars and vandalism based on who they are. So that's still part of our life. And we also enforce human trafficking, again, not in the context of anything around the criminal law side, but we handle the civil side in terms of someone who's forcing labor upon someone or trafficking in sex. We could bring a civil case to stop what's happening as well as paying damages. A little bit more about what we do at DFEH if we're kind of new to you. So we are the civil rights body, so we do a lot of training and technical assistance with regard to what are the laws in California. We investigate discrimination cases. So anyone can file a complaint with our office and we will investigate it if they're alleging discrimination in any of the workplace, housing, or in public accommodations. And then one thing that's kind of, I think, really helpful at DFEH, and this is also helpful when we talk about fair chance hiring, is that if you file a complaint with our office, we will offer free mediation with professional mediators to help maybe resolve the situation. And this is really helpful because I often get the question of, well, hey, if I file a complaint with DFEH, is it going to take 2 years for a resolution? And the mediation division of DFEH means that we can move complaints faster and get resolution for folks faster and get really great results. So that's just something that's great. We can maybe resolve things very early on. And then if we can't resolve it through mediation, and we believe that there is unlawful discrimination, we, DFEH, will file a lawsuit in state court to enforce the law. And we're enforcing the law on behalf of all Californians. So we don't necessarily represent the individual, but we represent the state, but the individual will also receive their remedies as well through our assistance. So a little bit more as we kind of roll into fair chance hiring. Just not gonna spend a lot of time, but just so folks know, in California, where you will find discrimination provisions is in what we call the Fair Employment and Housing Act. It's referred to as called the FEHA, and this is where you'll find all of the protections in employment and housing where you cannot discriminate on the basis of someone's protected characteristic. We're going to run through those later. Another thing, again, is the Unruh Civil Rights Act. This is what protects folks, again, in public life. So stores, businesses, barbershops, et cetera, they cannot discriminate on any of the protected bases, including race, gender, religion, disability. We'll go down the line. And we talked a little bit about our hate violence, but that's called the Ralph Civil Rights Act. This protects individuals from hate violence or threats of violence on the basis of a protected characteristic. So with Ralph, though, it makes it unlawful for any person to threaten or commit acts of violence against a person or property based on race, color, religion, ancestry, national origin, age, marital status, medical condition. The list keeps going: genetic information, disability, sex, gender identity, gender expression, sexual orientation, and even political affiliations, or even if a labor dispute issue. So this is really this law can really be. It's not just only major acts of threats. This can be just someone verbally threatening someone because of who they are. That's going to be a separate violation. So just a heads up. And then we have the Disabled Persons Act. Just again, in California, requires that if you are a person with a disability, you have all the same rights in public, the free use of all public spaces as a person with a disability. And then we talked about human trafficking a little bit, and that protects individuals against the deprivation or violation of their personal liberty by a person seeking to obtain forced labor or services, including sex. So I just like to point out with human trafficking that often the cases we get around forced labor, forcing someone to work at a kitchen who's maybe even underage for many hours under the threat of, if they don't do the work, we'll report you to ICE and have you deported. Another thing that we do that's just good for folks to know, because this would apply to community colleges and state colleges and every school in California, is that we also enforce the law with anyone who's receiving state money. So if you're receiving state funds and you're discriminating, someone could file a complaint with our office and we would have jurisdiction to get involved. So again, that's kind of our broad world that we do. So kind of moving into fair chance hiring, I think it's good to start kind of with our employment idea that, we at DFEH enforce the laws around discrimination in employment. And this is the list of everyone who is protected in the state of California from discrimination. We're going to be focusing today, and I'm going to try to use a cool little thing here, on, we're going to talk about, past criminal background and how is that a protected basis. We're going to talk about that. But just to run through, race is protected, and I'm not going to say a lot about it, but I do want to let folks know that starting January 1st, 2020, we've expanded our definition of race, so that now we are saying that race not only includes, our skin color, being African American, et cetera, but it also includes now hair textures and styles historically associated with race. So now we're saying that if you wear your hair in cornrows or dreadlocks or twists or braids, and an employer doesn't want to hire you or not promote you or something because of that, that'll be seen as racial discrimination. And of course, an Afro would be included as well. Afros had always been protected as being race, but now we've expanded it to say dreadlocks, twists, braids, cornrows, that would be unlawful for someone to say, I will not hire you because of that. So even though we're going to talk about fair chance hiring, I always want to make sure we know that good old-fashioned intentional discrimination is unlawful in California. And so it may not always be that someone's justice-involved past will be the issue. It may be that race is the issue. It may be that your sexual orientation will be the issue. Gender identity, et cetera, will be the issue. So I just always want to make sure that we're kind of up on that, because unfortunately that's the world we live in, where intentional discrimination still exists. So that's a little bit about all the protected classes, but we're going to zero in on that. Now, let's start with this. Now, I know we have a lot of folks who are really knowledgeable in the crowd today, which is great. So I look forward to any questions. But I just want to start broadly for folks who may not have heard of the Fair Chance Act. what is it, and let's start with that. So the Fair Chance Act is a law in California that has started in the last couple of years, that really is meant to deal with the disproportionality of mass incarceration in our state, which essentially means that we've seen a disproportionate numbers of African Americans and our Latinx community who have been incarcerated. So we have higher numbers of folks incarcerated than there are actually in the population. It's disproportionate. And later on today, I'm gonna try to explain why it's disproportionate when we take a look back at when the government was responsible for creating segregated communities and enforcing discriminatory housing laws that helped create segregated communities where it allowed for disproportionate enforcement standards with law enforcement. If I exclude everyone from one part of town and say all these folks live over here, it's much easier to police them and incarcerate them at disproportionate rates. And there are other factors as well, but that's one important factor of how we got here. So some data that I know many folks in the crowd are aware of, but I want to just highlight, is that we have just about over 2.2 million individuals in jail or prison right now in the United States. So that's an incredible amount of people. And we know that approximately 90% of the folks who are incarcerated are eventually going to be released into communities. So that's why these laws around employment and housing are so vital, because how are we going to ensure that people who are getting released and are coming back into the community are going to be able to have employment, have housing? Or are we just going to continue a cycle where people go back in because we don't have those resources? And then nearly half of all Black males, almost 40%, actually I can't, let me move my screen one second. Yeah, so nearly half of all Black males and almost 40% of white males are arrested by the time they're 23 years old. So we see the differences there. The number of Americans with criminal records is about the same as the number of Americans with a 4-year degree. So it's a high number. And although illicit drug use is approximately the same for African Americans as it is for white people, African Americans are much more likely to be arrested for drug use. So we know that we live in a world of disproportionality, and it's why we're here today. That's why we have a Fair Chance Act, is to try to resolve some of the underlying issues around this mass incarceration and disproportionality. And a little bit more here, again, I know folks may be aware, but when you look at the numbers, it's really stark, right? That this high amount of disproportionality. And you can look at any of these statistics, but the communities of color are affected. Between ages 18 to 19, you're 11.8 times more likely to be in prison than a white person, a male at the same age. African American females, twice as likely as white females to be in prison. And we know in our Latinx community that the disproportionate numbers are there as well. So we're living in this world where the numbers are clear. There's really no doubt that we have a disproportionate system of mass incarceration of communities of color. So I know maybe not new to folks here in the crowd, but just want to start from that level. Now, and this is just blowing that up a little bit bigger. Now, again, another thing that when we talk about fair chance hiring is really looking at this issue of implicit bias and structural racism, right? That we've had intentional discrimination through policies and government-sponsored laws that have kept folks down. But now, while we still have some of that, we're in a world now of implicit bias, where because of years and years of indoctrination, there is bias towards Black folks and our Latinx community, where we want to discriminate just because it's so implicit and so ingrained. So for instance, white men with criminal records are more likely to get an interview than a Black man with no criminal record. And when you think about that, you say, well, why would that be? Well, that's because of the implicit bias. That's because of what's been indoctrinated for decades, that a Black man is going to be violent. Is going to be someone who's, you don't want to hire because of what we've seen. And so now what we're trying to do is, how do we undo this implicit bias, this structural racism that's been created? That's a challenge. But these are the statistics that we see, and it's really why we need the Fair Chance Act. So which is why we need it. Here we are. So the Fair Chance Act, which went into effect on January 1st, 2018, is a California law that generally prohibits employers of more than 5 employees from asking about your conviction history before making you a job offer. And many may know this law as the ban the box law. So, I mean, really when you think about it, I know as long as I've, been up, we've always thought about, it's okay asking whether or not you've been convicted of a felony on a job application. And we know there's been many songs and artists who've written about this, including, even Ice Cube has some lyrics around this, and it's been part of kind of our popular culture. But now, under the Fair Chance Act, that's done. We can ask about it, and we can't even do, like I was at this conference today, and someone asked a question of, well, on our job application, can we say that you have to have a clean driving record? Well, you know what? That's going to give the appearance that you're asking about someone's justice-involved past. So really, we can't ask on the front end any information about someone's justice-involved past. So we're going to talk about that. But remember, this doesn't apply to every employer. It's the employers with 5 employees or more than 5 employees. Okay. Now, a little bit, and I have another graphic about how this works, but just to kind of walk you through it, and I'm actually going to use another little tool here. One second. Let's try this here. So what we're talking about with this law, just to kind of break it down, is when you're applying for a job here in the state of California now, we cannot ask about anyone's justice-involved past. Straight up, there could be nothing on the job application about that. Now, once you apply and you've been offered a conditional job offer, meaning, hey, we want to hire you, conditioned upon you doing the following things, an employer can conduct a background check. That's lawful. But that has to be after the offer has been made. And in the job application, they can't threaten it to exclude people. So now that they've offered you the job application or the conditional job offer, they're going to conduct their background check. That's fair. And if something comes up, then we get into this issue that the applicant has the opportunity to contest this. So here is where the employer has to conduct an individualized assessment of what was in that history of just being justice involved. And if they conduct an assessment, meaning going through factors to see whether or not this person would be a good fit, how long ago is the conviction, what type of work are they doing now, is it related, several factors that we'll talk about. But just to go broad, the employer has to make a decision of, are they going to make a decision to disqualify, or are they just going to go straight ahead and hire? So that's where we see this little arrow issue going, because if you just hire them, we don't have an issue. They understand the law, they went through the assessment, they said, hey, this person would be a great fit, they've shown evidence of rehabilitation, and the job they're doing is different than what the conviction was for. So that's how that works. But if it doesn't go, and they want to make a decision to disqualify, then the employer has several steps that they have to take. And if they don't take them, it would be considered discrimination. So for instance, if they say, yes, we want to disqualify you for your justice-involved past, the employer needs to provide a written notice of an intent to rescind the job offer, right? So an intent, it doesn't mean it's over. It means it's the intent that we are intending to take it back based on what we saw. And the employer needs to also include the records that they used to make that decision. Because as many folks know, there's a lot of errors and problems in the records of conviction and names and other things that were put on there that someone actually wasn't charged with or convicted of. So there's just that whole issue right there of is there false information? So we go through that. And then, if the employer has provided that notice and intent to rescind the job offer, the employer has to consider information provided by the applicant to counter that and say, no, you're wrong. I have a record of rehabilitation. You have the wrong person. There's wrong information. And the employer has to allow at least 5 days for an applicant to respond. And in fact, during those 5 days, the applicant could even say, hey, I intend to respond to this, but I got to go run down to the courthouse and get all this information. So you get additional time additional 5 days to do that in that situation. And so then once the applicant has sent that information of, hey, consider me, here's my record, et cetera, the employer has to make a decision now and consider that evidence. And they have to consider it. They can't say, I'm not going to consider it. And we get that case often, and that would be a violation to say, no, we're rescinding, we don't care what you give us. So then once you've turned over the information, they are going to need to decide if there's going to be a written decision, or a final decision to disqualify. And at that point, if they do disqualify, then they're going to need to provide a written notice of that. And it has to be in writing, and it has to include information so that you can call our office, the Department of Fair Employment and Housing, to make a complaint. So, just a little diagram I just thought was a little helpful, because with this law, it really is very much procedure. It's talking about timeframes and considering evidence and this back and forth. And out of the total of almost 600 complaints we've received since the law has passed that have alleged this, that there's almost always a violation somewhere in here where someone is not provided, the employer hasn't provided the information, left out DFH's information. So there can be a lot of procedural violations here that we've seen. Doesn't mean that every complaint that comes to us, there'll be a violation, or that we would find cause to go further, but just along these steps, there can be violations that ultimately could come to our attention. So just trying to point out what we're talking about here. So let me zoom out for a second here. 1 second. Okay. So I got 2. Okay, there we go, cool. All right, so now let's talk about how the law works. So the first one, is, again, the law prohibits employers from including on a job application any questions about conviction history before a conditional job offer has been made. So if you're out there and you're helping folks get a job, or you yourself encounter this, where on the job application it says, have you ever been convicted of a felony? That is a violation, and you should make a complaint to us. You should let us know. Because again, not even if you don't want to pursue it, or you're concerned, it's important to let us know, because we have the ability to bring broader systemic director's complaints. So we want to hear about that and try to resolve those issues with employers if they haven't revised their forms and are asking that question. Secondly, they cannot ask about or consider any criminal history before the job offer has been made. But just again, we don't even go down that road. Now, considering information about arrests not followed by conviction, participation in pre-trial, post-trial diversion programs, or convictions that have been sealed, dismissed, or expunged, or statutorily eradicated, we can't do that. The employer can't do that. And I would add in here that's not in the slide, that if someone's been pardoned or received a certificate of rehabilitation, those are also ways where you could answer no, or that this isn't an issue, that you do not have a record that should be subject to consideration. Now, after offering you a job, employers are allowed to conduct a criminal history check. Okay, so that's true, they can do that. But the law requires that an individualized assessment about your conviction history. So here the employer has to, it's not a one-size-fits-all. They really need to look at the individualized assessment about this individual's justice-involved past. So this means that an employer can't take back the job offer without first considering, one, the nature and gravity of the criminal history. So what was it? What was the alleged act that someone was convicted of? And what was the gravity of it? So that's the first thing we want to look to, is, was this something very significant? Was it something minor? We don't know. So we got to first take a look at what was it. Excuse me, a little drink here. 2 was the time that has passed since the conviction and the nature of the job that someone is seeking. So remember, we're looking at the date of conviction, right? So if I went down 20 years ago and I got released yesterday, we're not looking at the date I was released. We're looking at the date of the conviction and the nature of the job that I'm seeking. And by this, we're looking to the relationship, right? So someone maybe was convicted of DUI, driving offenses, or perhaps, so let's stick to that example. And then now they're going to be, driving a rental car. That's closely related, as opposed to I was convicted of a driving offense, DUI or something, and I'm working as a bank teller. Okay, there's no relationship there. So we need to. That's one issue with employers. We need to see the relationship between those two. Now, if the employer decides to take back the job offer based upon the justice-involved history, they must tell you so in writing, provide a copy of any conviction history report they relied on, and give you at least 5 business days to respond. So, again, sometimes what we see is, someone will just get a phone call. Hey, we're taking back the job offer. We ran your history. Sorry. Well, that's not good enough. It needs to be in writing. And they need to provide that copy of what they used. Because as we'll talk about later, there are a lot of errors on this. And so we need to see that first. And then you have 5 days to respond, to provide information that, no, you have it wrong, or no, I have proof of rehabilitation or other documents that show that I would be a good fit here. So you have that ability to get involved in this part of the process. And again, you can request additional time within those 5 days. Now, I talked about that all employers with 5 or more are going to be covered here. But there are some exceptions here, so public and private employers with 5 or more employees are covered by the law. That's true. There are some exceptions. The exception is that the law does not apply to certain positions at healthcare facilities, farm labor contractors, or positions with state criminal justice agencies, right? So there's other laws that tell these folks that they need to do these background checks, and that's lawful if you can point to a law that says we have to do this. We, the state attorney general's office, have to do this background check first. Okay, so that's limited exceptions there. It also does not apply to any position where an employer is required by another law to conduct background checks or restrict employment based on criminal history. So perhaps it's, someone has they're based here in California, but they have a federal contract with the federal government or something to that extent, and there's another law that requires them to do that. Perhaps it's like a defense contractor and they have to do security clearance and it comes up. So there's that issue. So there's some limited exception here. But after conditional offer of employment, has been made, what can an employer ask about my justice-involved past? Well, after conditional offer, an employer may ask if you have any history of conviction. So they can ask that. But employers may not ask about or consider information about one arrest that did not result in conviction. Okay, and there are some exceptions there in the labor code, but generally one cannot ask about any kind of arrest that did not result in conviction. As we know, many folks are arrested, never result in conviction, and so therefore there's really absolutely no need to be looking at that. 2 is, again, employers may not ask about or consider is whether I was referred to our participation in a pretrial post-trial diversion program. We see that come up occasionally as being a concern. And 3, convictions that have been sealed, dismissed, expunged, or statutorily eradicated, and we can include there either a pardon or a certificate of rehabilitation that you've received from the state. So that is, we cannot ask about it. We get to say no to all of that information. Now, what is permissible after a conditional job offer? And let me just take a moment to say that on our website, we have packages for employers that list out, the types of questions that could be asked or how they should be going around the individualized assessment. We have a sample conditional job offer policy. So we have resources to actually help folks out. So I just want to make it clear that there are resources. Now, this question of what is permissible after this conditional job offer. So you've applied, now they're saying, hey, we want to hire you. They can ask you, have you ever been convicted of a misdemeanor or felony? But you're going to answer no if, A, you've never been convicted of a misdemeanor or felony. 2, the misdemeanor or felony was sealed, dismissed, expunged, or reversed on appeal. Or 3, withdrew after completing a court program and were not convicted of a misdemeanor or felony, right? So you get to answer no in those three circumstances. Now, what happens if an employer learns about my conviction history and wants to take back the job offer? So again, the first thing is, if they want to do that, the law allows it, but they have to first conduct this individualized assessment. So again, just to kind of review it again, the nature and gravity, what was the harm caused? What was the nature of it? Was it something violent? Was it something non-violent? Let's go through that. The amount of time that has passed since the conviction. Was it 6 months ago, the conviction? Was it 10 years ago? Obviously, the longer the time goes, the more it leans on the side of this person should be hired. The nature of the job you are seeking. So what are the essential functions of the job environment? How do they relate to this justice involved past? Is there no relationship between, as the example we used earlier of some type of driving conviction around DUI and, working in an office? There isn't. What are the essential functions? And the employer cannot simply say that they won't hire someone convicted of a certain crime. So that's the important part. You can't say, well, we'll do an individualized assessment, but if it's this one, that's a no. No, you have to conduct the individualized assessment. So, I think the key here is that this is meant to give folks a lot of hope, and that they have a right to work. And if you go through this assessment, it could sometimes err on the other side of the employer, but generally, if we go through this, it may be that many more folks are getting hired when we actually go through the assessment. So again, the employer there must be notification in writing. The employer must notify you in writing of the preliminary decision that your conviction history disqualifies you from employment. So that's a big step. Again, I just point out that we may not always see followed, where it could be just a phone call. That's not enough. 2, notice of disqualifying conviction. The employer must provide you a notice of the convictions that disqualify you from employment. So they have to list those out. What specifically is the conviction that's the issue? And 3, a copy of the conviction history. So if the employer obtained a copy of your conviction history report, they must provide you with a copy of the report, because many of these may not be accurate and you need to be able to challenge them. And again, if they don't give that to you, that's a problem, and you could file a complaint. Excuse me. So the chance to respond. So the employer is required to give you at least 5 business days to respond to the preliminary decision to take back the job offer. And it has to tell you that you can respond. And then if you dispute the conviction history report or otherwise want to give information to clarify, and you tell the employer within 5 days, they have to give you an additional 5 days to respond. So I just think that's just kind of a little helpful thing if, for the service providers and folks who are working with anyone justice involved in this situation, that you can wave the flag within that 5 days of, hey, I'm going to challenge that. You have it wrong. You need to see additional evidence. But that also gives you that additional 5 days to get information. So just again, another, while kind of procedural and technical, if someone doesn't allow it, has already sent the final notice to you, that would be a violation. And so here's kind of another look at this process. So, the employer is required to tell you that your response can include, and let me just use my little pen here. So now we're at the part where the employer is telling you that we're not going to hire you, or we're going to take back the job offer. But you can, respond to this, and you can include any evidence challenging the accuracy of the conviction history report. So, I used to work as a law clerk at the public defender, and there are oftentimes inaccuracies in the conviction history report. Because this gets very clerical. People are typing in stuff, typing the wrong stuff, or they don't get it right. So you really need to look at that and don't assume that that's totally correct. 2 is, your response can include any evidence of your rehabilitation or circumstances that you believe are important for the employer to consider, right? And again, this is the employer telling you that you have a right to challenge on these grounds. They have to tell you this. So we have that. Yeah, and examples of this evidence include your employment history. So maybe you've been working already for a while, or an explanation of circumstances about your involvement in the alleged crime. Maybe I wasn't, I went down for something, but I really wasn't involved. It was something where, perhaps a felony was committed by me just being there, but I wasn't actually involved in it. So it's an example of I wasn't the one who perhaps did the act that I'm being accused of. I was just an accessory, a co-conspirator, something like that. So those are examples. And then rehabilitation efforts, which is really important, such as I've been doing training, been doing education. I've made a lot of great efforts to rehabilitate myself. And so you want to show that evidence. And that's where I think, with our service providers and people in the justice community, it can be very helpful to help the applicant find that information, that they have done training and education, has certificates and other aspects that could be challenged. So this is one where you have to really kind of gear up and be ready to challenge and obtain information to your best of your ability, and perhaps even get some assistance with challenging that. Okay, so in the consideration of your response, the employer must consider any information you submit in the response. So they need to consider it. And the final notification must be in writing, and after considering any information you submit, the employer must notify you in writing of, one, the final disqualification of the job, any procedure the employer has in place to challenge a final disqualification. So some employers have another procedure to challenge that. And then the third option is they have to tell you that you can file a complaint with our office, DFEH. And a lot of folks will, perhaps try to leave this one off and just say, and leave this one off. Just say, hey, we're disqualifying you, but they don't put this here. Because, not everyone, like I said, I go around the state, many folks don't know about who we are. And so if you just get this disqualification, you may think, well, that's how it is. But no, you do have a right to file a complaint with our office. It is free. There's no charge. There's no attorney's fees if your complaint is not accepted. No, that's a right that you have. And again, if folks aren't following the laws we laid out, then that is an opportunity where a complaint should be filed. And we have a lot of ways to remedy that. And even if it appears to you to be like a small violation, or they didn't put this on there, it still is good to let us know, because we have the ability to use what's called injunctive relief, which means, not that we're asking people to pay money, but require them to change their rules and policies and obtain training. So we have that. Now what remedies are available, right? If someone does violate the law, and so you apply, and they asked about conviction history up front, or they didn't consider any evidence, well, there could be issues around, remedies of getting back pay. Like, what were the, if like you were disqualified from like a promotion because of a past conviction history, that could be back pay. There could be front pay, future lost earnings because they didn't hire you. We've had people reinstated or hired. So sometimes, again, these cases come up within the application process. Sometimes they come up when someone's applying for a promotion. But so we get people hired or reinstated. We get people promoted as a part of the remedies that are available. There can be out-of-pocket expenses, meaning, money that the discrimination of the employer that was out of my pocket, travel time, daycare time, all this time that I spent challenging this, or the damage that it caused me since I didn't have the job that I actually paid, or I got a different job that was further away and it cost me more money to go there than the job that I really wanted. Another remedy is policy changes, the ability to change policies at the employer so that they are following the Fair Chance Act. And then oftentimes, if we do that, we're asking that folks get trained, that the employer take training on broad discrimination principles in the Fair Chance Act. And a whole host of other remedies, including emotional distress. And punitive damages, too, are on the table. That's where the employer is acting with malice or kind of egregious behavior in their discrimination. And of course, with all of this, the employer can be on the hook for attorney's fees and costs. So there are definitely a lot of remedies available. And again, I would just reiterate here, because I understand folks who would say, hey, I want to file a complaint, but I don't have 2 years. I don't have a year and a half to do this. What's the time frame? And it's true that an investigation can take some time. But the issue of our mediation department means that these cases can get before a mediator very quickly. And so perhaps the mediator is able to get the job back, get you reinstated, can deal with this earlier. So that's why I would encourage, I would say, folks, if the law's been violated, file a complaint, because we need to know and we want to help you. And we have the opportunity to actually make a change because we have investigators who do this Fair Chance Act explicitly, and then we have lawyers who litigate these cases. So, so there are remedies for folks. So, and when I go around town, I always hear folks saying, "Oh, did you hear about, X employers asking about this or X person's doing that?" And if complaints aren't filed, we will never know. So we need to know. That's why this is so important. So you're trained as kind of frontline responders to discrimination that's occurring. So basically, I want to leave some time for questions for our part one, and then we can get into some questions for part two, where we're going to talk about housing. But Kelly, I'll throw it to you before I move into housing. If there's any questions people may have about what we've talked about so far, any clarifications.
Yeah, so far we've had a couple of questions come in, and right now feel free to type them into the Q&A chat box, and we'll make sure that we get to those as well. But generally, someone was asking if it was possible to request from your office like a facilitated workshop on fair chance hiring, and if so, what is the process for making that request?
Yeah, no, that's great. We definitely would love to be part of that and facilitate a workshop. I would say the best way, I'd say two ways. One is you can reach out to me directly, and I believe my email is at the end of this, or I can give it to folks now, whatever is easiest. I'll just give it to you right now, and then I'll give you the other way. So my email, just so folks know, my first name is Branden, and I spell it with an E. So it's BRANDEN, and then it's .butler, BUTLER, at dfeh.ca.gov. And if you missed it, it'll show up at the end, and I think it's at the front. The second way is if you go to our website, which is in the process of being remodeled, you'll be able to request a speaker engagement form. So you can fill out like this little form. It asks questions of like what you're trying to do, what do you want to do, and then it goes to me, and then I review it, and then that's certainly something we'd want to do. And any way we can partner with folks is really key for us, because we'd like to do workshops throughout the state to get more awareness about the Fair Chance Act. So yeah, definitely, really into that.
That's great, and I'm assuming it was an anonymous question, but I'm assuming it was from one of our campus providers, since that's mostly who I see on here, or a student. And so, yeah, if you didn't catch the email or you are not sure you want to do it now, but in the future, you can reach out to Branden, you can reach out to me, I'll connect you to Branden, whatever is easiest.
Yeah, absolutely.
Another question that came in was, does this information apply to both public and private employment applications?
It does. So yes, it does apply if it's a state school, if it's this, the state, of itself. Yeah, private. The key is that we have 5 or more. So if it's a small shop and there's 2 people, that goes with unfortunately all of our discrimination laws. They're not covered as an employer if there's less than 5. But except for the exceptions where it's like, maybe a law enforcement position or something where by law they can ask, that would be the only area. But generally, it's going to be all public, all private folks of 5 or more.
That's great. That's really helpful. Another question that we have, someone was sharing that in the past they've been disqualified for a job even after the expungement process was done. When they requested sort of information in writing as to why, the employer stated that they would not be able to do that. This happened a few years ago, and so they're sort of curious how and what can be done now. I'm guessing they're asking what can be done now in regards to that particular situation.
Yeah. Well, one thing I didn't mention is, what's like the statute of limitations, like how far can we go back on when there's been a violation of the Fair Chance Act? It generally breaks down this way, is that for our office to take a complaint, it has to, the last act of discrimination has to have occurred within a year. right? So the last act. Now this is a tricky question because sometimes discrimination is ongoing, and it's what we call a continuing violation. So sometimes that last act was yesterday. So so it's a tricky question, and sometimes you may not have discovered the act of discrimination. Like let's say you just were told, "Oh, we're not going to hire you," but then you find out later on it was really because they didn't want anyone with a justice involved path. Well, now you just got aware to it, and so sometimes the statute of limitation doesn't necessarily start in those situations. So I would tell folks in those, that you could err on the side of caution and file the complaint. But if someone, if this happened before the Fair Chance Act, then there certainly wouldn't be the ability to bring a case. But let's say, like I said, you didn't know about it or you just heard about it, it could be. But generally, it's a year deal, and then it's 2 years to bring a private lawsuit. So not with our office, but just privately on your own, you'd have 2 years to bring that. But it's 1 year to file a complaint with our office.
Yeah, thanks for answering that. And so it really sort of hits home the fact that when something does occur,
Yeah.
you are better off just acting quickly on that.
I encourage folks, it's okay just to file. We have a ton of investigators. We want these complaints, and if it's actionable, we'll go forward. Either way, it creates a public record too, right? So that there's a way of folks to identify, oh, we've been getting several complaints about one group all over the state. So it's helpful because if it's happening to one person, it's probably happening on a larger scale. So, and I get it that it's really hard to want to go forward, and you're busy and you're trying to work and live, and I get all that. But without y'all on the training here today, we're not going to be able to kind of root out these issues. So definitely.
Yeah. Okay, someone just asked for clarification on, they said, if I go through the hiring process and I am denied, what are the time limits for me to file an appeal or complaint with your department, which you may have just answered. But.
Yeah. So that would be the 1 year. So like, let's say you're denied, September 1, let's say 2019, you'd have 1 year to bring that complaint. So, and that's helpful, right? Because sometimes you're like, hey, I'm just trying to get a job right now. I don't have time to do this and that, and I'm running. So let's say you get your job and you get settled, and then you're like, you know what, I want to deal with that discrimination that happened that wasn't right. You have that time, so that's okay. And the key with all of these things is just, in terms of best practices is, keep records, right? Keep data, because not every person's going to put it in writing. Maybe it's a text message. Maybe it's you have the original advertisement. Keep these things, because if there is a complaint, we're going to need evidence. And, so your records, the emails, the letters is really helpful. So yeah, you have a year to file it with our office.
Yeah. And I love the point you just brought up about if you are in a pinch and you really do need a job, this doesn't mean that you have to drop everything you're doing and go get a job.
Right.
Or drop everything you're doing, not get a job, and then file the complaint. It does mean you have the time to set yourself up, get employment, get your paycheck, and then go ahead and make that complaint. I love that.
Right. It doesn't affect your case. I mean, it's not like, oh, hey, you waited, so therefore it's not, it's really not a real complaint. No, you have that right. It's, and there's many reasons why someone would want to wait, but certainly I can imagine in this situation, because we're talking about getting a job, you need a job, and it's really hard to be in a position to file a complaint when you're looking for that. And again, a lot of this too goes to damages. Hey, I got blank job, but I really wanted the other job, and now it's far away across town. I have to get daycare. I'm spending money. Those issues go to your damages. So sometimes in the law we practice, there's damages. And that's the hard part about what we do, is that sometimes we're not able to resolve it before the damage occurred. Someone didn't get the job, and now they're, ABC across town, and it's expensive. So all of those issues, when you're in a position to file a complaint, can go to your damages.
That's great. We have one final question before we move on. And this person asked, does this apply to student workers at the community college level? And I'm wondering if the person is asking about like a work study position in particular, which I'm not sure. Yeah.
That's interesting. I mean, if the person is technically an employee, right? I mean, I don't know if I could. I'd have to look a little deeper in terms of like the work study arrangement and are they classified as an employee. But if someone's, receiving, a tax statement, and they're working and their hours are controlled, then it would seem to me to be on the side of that they're an employee. And definitely the employer, the state or whoever, would definitely be of 5 or more. So that would be one where again, I don't think someone could discriminate there and say, well, we're going to ask you if you've ever been convicted of anything on the front end because it's a work study deal.
Yeah.
I don't know, but to me that would be, it gets close to an employee, but we'd have to double check that because that's kind of an interesting point, but I would err on the side of that. It most likely would be.
I think perhaps that if the person is asking about federal student working money, we can follow up with them in particular afterwards and give you.
Yeah, that would be good.
Yeah,
That'd be good.
I have their name. We'll follow up.
Okay.
Okay, great. So that's all of the questions that have come in for now. So unless anyone has anything else, we'll continue moving forward.
Just one question I have, because since I've started this presentation, like folks are sawing or whatever here at Disneyland. Are you guys hearing that, or does it sound okay?
I
You're not.
can hear well. Yeah, you're
Not hearing sawing or anything. Okay. Yeah, because I swear, as soon as we started, got the chainsaw out here. So Mickey is working hard here. So let me get into housing. I every time I talk about fair chance hiring, I just find it like we have to talk about housing because I think housing is the issue of our time. Whether it be there's no affordable housing, there's not enough housing, people are discriminating in housing. Housing is like the key, and so when you can't obtain housing, it affects everything else. And so, as others have said, when we talk about housing in the context of past justice-involved past, what's happening is folks are getting locked up, and then when they get out, they're being locked out of housing, and it creates this revolving door. And so housing is definitely a really important piece. So we're going to talk about how do we unlock the barriers to obtaining housing. This is really cutting edge stuff here. It's very new, and we're going to break it down. So again, we already saw this data, but I just want to first get back to the idea that we have mass disproportionality with folks who have been convicted of alleged crimes. And so we know that it's predominantly disproportionately people of color. And that's an important fact because, again, if we look at like the idea that we have all these folks who have been disproportionately incarcerated based on and they're persons of color, and then if we say in housing we're going to have a preference that we only want to rent to people who don't have a past conviction history, then what we've really done is we've locked out people from housing, from never getting it. And that's really the background of what we're talking about. And again, 30% of the US population has a record, right? So we know we're talking about a large group of folks. And this means, you had one from 50 years ago. There's been many a case of folks trying to get into senior housing and, felony conviction comes up from 40 years ago and they're not getting the housing. This is why, these laws are changing now because these things don't make sense and folks are being locked out of housing. Now, I'm going to pop to some maps here, and I'm going to zoom around a little bit to make it a little bit more readable. But just to take a step back, let me go over here. I talked earlier about, how did we get here? How did we get to this disproportionality of Black and Latino communities being incarcerated at much higher rates? How did we get here? Well, I think you have to start back when the government was responsible for creating and enforced laws that allowed discrimination. So up until, here in California in 1962, you could lawfully discriminate on the basis of race all across this country. And so what you saw land development occur where we were essentially redlining and segregating communities of color. And so this is what started to happen. So this map that you're looking at is actually a map of Los Angeles, and it was made in 1940 by the Homeowners Loan Corporation. And the Homeowners Loan Corporation was basically this kind of quasi-government body that was created by the New Deal FDR to kind of go around the country and rate the cities for what was a good place to invest money in, what was a place where we should put money so that we don't have another Great Depression. That was the idea. So they went all around the United States and they developed these maps. And basically, in these maps, they would rate them as being, a good place to lend money would be green, Blue was okay, yellow was like it's going the wrong way, and red was this is a bad area. Don't put any money here. And as you can imagine, the red areas were the places that all the people of color lived. And these patterns occurred. Now again, the people of color just didn't end up there. This was because this was the area they could live due to segregation. So you had these patterns. So here you're looking at this area highlighted here is Watts. And so I'm going to show you what they were saying about Watts here. So let me just click out. Okay. So so in the map, and you can find this at Mapping Inequality if you Google that. The University out in Richmond did a great job with this, and they've taken all the records and all the data and put it into this program so we can all look at it. But basically, when you look at the map here, and hold on one second. I apologize. They're just like grinding right above my head. I'm going to just move for 1 second. Just hang with me. Sorry. I'm just going to walk over to the other side here. I apologize. Okay. Sorry, much better. Okay. All right. So this map that we're looking at is the actual description of what was said at the time, and I have it here on the next slide, so you don't have to read it. But again, this was just the business they were doing. They were looking at property, saying, okay, let's look at Watts. How is it? And Watts, they say, says this area, which is located in both the county and city territory, is known as the Watts District. It contains one of the largest concentration, again, this 1940s language, of Negroes in Los Angeles County. There are also many Mexican and Japanese residents, the latter usually occupying garden tracts largely constructed in the southern portion. Construction is predominantly substandard, and much of it is of the shack variety. Maintenance is of poor character. Population improvements are highly heterogeneous, meaning that it's not exclusively white. And while slum conditions do not yet prevail, the trend is definitely in that direction. The area is thoroughly blighted and is accorded a low red grade. So here we see as early as 1940 the segregation occurring already out there, that this area had to be excluded and disinvested. And so again, when you think about if we separate everyone and then we police it differently, it's very easy to know where groups are because we've put them in little areas. Another one I thought to show was Boyle Heights. So you see it's red, and you see, again, if you know LA, you'll see the areas that are where it's surrounding are predominantly places where people of color live. And what they were saying here about it is this. It says, Boyle Heights, this is a melting pot area and is literally honeycombed with diverse and subversive racial elements. It is seriously doubted whether there is a single block in this area which does not contain detrimental racial elements. And there are very few districts which are not hopelessly heterogeneous in type of improvement and quality of maintenance. So again, this is where we were, and you can understand why when you fast forward 50, 60 years, we're still dealing with these issues because of what was happening. Now, I threw a couple more on here just because, I'm from San Diego, and we may have some fellow San Diegans on the line. But this is a picture of the original San Diego redlining map from the Homeowners Loan Corporation. And if you know San Diego, here's Balboa Park right here. Here's the water, downtown now. But if you know San Diego, I used to work in Southeast San Diego, and even as early as 1940, this area was red, meaning blighted. Don't rent there, don't buy there, don't put money into this area. And that the community, as you know, is predominantly people of color, still feel those effects today from the disinvestment. And just to walk through a little bit of the San Diego map. Now this one I have to zoom on, so let me zoom up for you. So this is the actual document we're looking at that was written at the time, and I'm going to read you a part of the map that's showing you what's called the Talmadge area of San Diego. It's predominantly white, predominantly wealthy now. And what it reads here, I'll just read it for you. It says the topography of gentle canyons and mesa lands are adapted to high-class landscaping. Canyons are considered very desirable for home sites. Residents are white, with a few of the upper-class Spanish families consisting of naval officers, business and professional men, and retired people. Income range is $3,500 and up, or $3,600 and up. And then it says no ratio of concentration, no threat of infiltration restricted to the Caucasian race. And I just bring this up because, again, we saw that the areas of wealth where people could earn money and were invested in, they were, people of color were excluded. They couldn't live there. And when we think about how do we have disproportionate policing, disproportionate incarceration rates, a lot of this goes back to this. So I think it's just a fascinating part of our history. So, and then this one I tried to mark up a little bit ahead of time so you could see, and I'll zoom in a little bit. But what this is showing you here is now what's kind of like the downtown area, but at the time it was considered a yellow area of San Diego. And I'm just going to read to you what it says. It says, and I'm just right here, it says, this area lies along the bay and is a desirable district. However, in this area is located the servants' quarters of the colored population of Coronado. There is considerable building going on in this area, and were it not for the colored population and a dump at the northeast portion of the area, this would be classified as a blue area. It is absolutely desirable with the exception of the facts set forth above, but it is necessary for this exclusive city to have such an area. And, you know, again, I just point this out because the discrimination and segregation is kind of as old as time. And we see the impact of what was said then and the treatment of the explicit and the implicit bias and how it relates to today. So it's really hard to understand our history unless we are where we are now without looking at our history. So I just wanted to share that with you. And then just briefly, these other maps that we're going to get into fair housing, this is really trying to show you, like here's a map of San Diego. This map right here is showing you where are the areas of poverty and race when you look at it. And if you ever get confused of like what we're looking at, look to the coast because that's predominantly wealthy and white. But right here is that red section I showed you earlier of Southeast San Diego. And lo and behold, today it is the poorest area of San Diego, and it's predominantly where people of color live. And this map is showing you the orange dots represent the white population, blue, Latino, and green is a few green dots in there. If we zoom in, represent I'll try to zoom in here for you, represent the other groups. But you'll see again in this map, predominantly all white on the coast, wealthy. And that area I showed you before, if we go back, that was lighter in color, was poverty. And now we put the dots of race over it. And so you see this overlay of, 50, 60 years later, the same thing is going on. It's impoverished and it's predominantly people of color. So just showing you the effects of what happened 50, 60 years ago go with us. And, this map just gets to, again, kind of showing the overlay of race and poverty rates together. And these maps come from HUD, actually. So, they were put out. And the data is a little bit old, from the late 2010s, but the idea is still key. I wanted to, again, just highlight here, you see the lighter areas here is where the poverty is, and it's predominantly the people of color, the Asian community, Latino community, and the Black community, who are basically segregated out from the entire region. So just highlighting that. And then if you know San Diego, here are some of the areas where we see the what's going on. So like La Jolla, predominantly white, extremely wealthy. It still is today, was then. And then here you see southeastern San Diego, City Heights, downtown, where people of color are basically in this quadrant only. And this one is just showing where all the low-income housing is in San Diego. And again, it's mostly located here. So what's happened is folks have been kind of segregated into one area, and you've put all the affordable housing in one area, and it doesn't necessarily allow the same opportunities when we concentrate poverty into one area. So anyhow, now kind of jumping out of this into, well, this is why under California law and under our federal law, believe it or not, and as the former HUD Secretary Julian Castro said, when landlords similarly refuse to rent to anyone who has an arrest record, they may effectively and disproportionately bar the door to millions of folks of color for no good reason at all. And that's really what we're talking about, is that if you look at all that past, and then you come up with rules that say, I won't rent to someone who has a justice-involved past, a lot of folks are not going to have a place to live because of this disproportionality and segregation we talked about. So these are protected classes. Again, we're going to be focusing in on race. Now, a little bit about our data. I'm going to move through it, but these are the complaints that we received in the last couple of years. Disability is usually our number one fair housing complaint for housing discrimination. But you'll see that race is right up here as our one of our biggest areas. So just in general, race lives with us, and it is the second largest complaint that we have received. Now, when we talk about fair housing laws, I just want to be clear that these apply to all types of housing. It's not just apartments or low-income housing. The laws that we're going to talk about apply to all housing providers, that the landlords, the homeowners association, the agents, the builders, whoever. Now, the important factor and why this is important is that we need stable housing to reduce recidivism rates, right? Each time one moves after release from prison, there's an increased chance of rearrest by 25%. So we need to create stable housing instead of what often is the case of people are shuffling around from all different types of housing because they can't find anything permanent because of the housing crisis and these rules that prevent folks with a justice-involved past from moving in. Why do we need? We know that 95% of folks who are inside are going to be released at some point, but we need housing. We got to figure this out. And what was interesting, believe it or not, is when Obama was in office, he issued some guidance that our state laws are looking to mimic, basically. And I'm going to go through some of this HUD guidance. So what we know, what did HUD say about this? So HUD said, and again, this is the federal government saying, that across the United States, African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population. Consequently, criminal records-based barriers to housing are likely to have a disproportionate impact on minority home seekers, right? So, maybe the law is neutral, saying, hey, we're just going to run everyone's background. But the impact of that will be that people of color will be disproportionately kept out of housing because of what we've been discussing. Now, again, what do we know what HUD said? HUD said, well, while having a criminal record is not a protected characteristic under the Fair Housing Act, criminal history-based restrictions on housing opportunities violate the Fair Housing Act if, without justification, their burden falls more often on renters or other housing market participants of one race or national origin over the other. So this is what we call this discriminatory effects. It means that while the law may be neutral, it didn't say we want to keep, Latino people out of housing. But if the effect of the rule is that a lot of Latino and African Americans will be kept out of housing, that law has a disproportionate effect. And we need to look at, is there a lesser discriminatory way to do this? And there is, right? We should be doing the individualized assessment again, like we talked about earlier. Let's not have blanket bans. We're going to talk about that. So, but before we get there, it's important to remember, just like we talked about on the employment side, intentional discrimination occurs. It can occur. We're not, it's not always about just criminal history. It can just be straight up intentional discrimination. So intentional discrimination occurs if a housing provider treats individuals with a comparable criminal history differently because of their race, national origin, or other protected class, right? So if I'm going to allow someone to live here who has the same exact conviction as the black applicant and the white applicant, but I feel more comfortable with the white applicant, that can be intentional discrimination. Where it's just because of race, not the criminal history. So again, here's a situation. Housing provider rejected a Hispanic applicant based on his criminal record, but admitted a non-Hispanic white applicant with a comparable criminal record. A policy of not renting to persons with certain convictions, but makes exceptions to it for whites but not African Americans is intentional discrimination. So you just want to make clear we still have that. And another one is a leasing agent assisted a white applicant seeking to secure approval of his rental application despite potentially disqualifying criminal record under the housing provider screening policy, right? So the policy was, hey, you're not going to make it here, but I'm going to, let you in here because, I feel comfortable with you, but I'm not going to do it for the African American. That's intentional discrimination. But let's talk about, so yeah, at this time, we don't have a similar fair housing law or fair chance housing law at this time. But what I will say is we have this federal guidance, and there are regulations that our regulatory body makes, and in the proposed regulations that are not yet final, and you can review them on our website, there is discussion about how there appears to be a similar procedure as we saw with fair chance hiring that will be coming out. So just something, I can't talk a lot about it because they're not approved, but you can check our website to look at the proposed fair housing regulations that discuss a lot about how folks with a justice involved past should be treated in housing. But it basically mirrors what we're talking about today, so it's not really substantive change. So the idea is that, so when we talk about discriminatory effects, we're talking about, again, this idea of that it's just a policy or practice that restricts access to housing on the basis of criminal history could have a disparate impact on an individuals of a particular race, national origin, if the policy or practice would be unlawful under the Fair Housing Act if it is not necessary to serve a substantial, legitimate, non-discriminatory interest. So basically saying, look, if you're a housing provider and you want to have a criminal history background check, okay, you can have it, but it has to be necessary to serve some substantial, legitimate, non-discriminatory interest. And we have to look if such interest could be served by another practice that has a less discriminatory effect, right? So instead of, we're going to have a blanket ban that says we won't rent to anyone with any conviction, no matter when it happened. What about doing the individualized assessment and looking back at, well, when was it? What was it for? Evidence of rehabilitation. That's a less discriminatory way, but it still serves that interest of wanting to ensure that the right folks are there. So there's a lesser way to do this. So a housing provider will violate the Fair Housing when the provider's policy or practice has an unjustified discriminatory effect, even when there's no intent. So in this type of case, we're not saying that there was an intent to keep people of color out, but the effect of the law is, and that's still liable. Again, more data that of the disproportionality, and I want to move through because I know we're going to run out of time a little bit. But evidence of impact, again, Hispanics were similarly incarcerated at a rate disproportionate to their population. Same with African Americans. In contrast, non-Hispanic whites comprise approximately 62% of the total U.S. population, but only about 34% of the prison population. Right, so that's very stark. And across all age groups, the imprisonment rates for African American males is almost 6 times greater than for white males. And for Hispanic males, it is over twice that for non-Hispanic white males. And, we have a lot of data about the incarceration rates between women and white women and people of color. I'm going to leave that so you can check that out because we got a few other things I want to cover. So again, when we look at what HUD has said for how we would look at these issues, you have to prove that the criminal history policy has this discriminatory effect. So we have to really look at, there's some level of statistics involved a little bit. The state proposed regulations kind of move away from that and just kind of create a mechanism. But the idea, anytime we're talking about disparate impact, we have to show that there's actually an impact. So it would be looking at some of the data we've already shown to be fairly easy to show. And again, HUD guidance here, they say a housing provider policy or practice of making housing decisions based on criminal history, they have to show that it actually assists in protecting resident safety. Because a bald assertion based on generalizations or stereotypes that an individual with an arrest or a conviction record poses a greater risk than any individual without a record is not sufficient. So you can't have blanket bans anymore in housing. That's what you take away from it. You can't have a rule that says we will never rent to anyone with a felony conviction. That's going to be unlawful. Okay, now they can still run the check and they're going to have to do the individualized assessment, but we can't just on its face say you can never live here. And then a couple of additional slides here that I want to talk about is that a housing provider with a policy or practice of excluding individuals because of one or more prior arrests without any convictions can't satisfy this burden. So you cannot have an arrest record check. That's going to be unlawful. And again, a housing provider that imposes a blanket prohibition on any person with any conviction record cannot satisfy this burden. And a policy or practice that fails to take into account the nature and severity of an individual's conviction is unlikely to satisfy. So again, that's the individualized assessment. What was it? What was that similar language of the nature and gravity? A policy or practice that does not consider the amount of time that has passed since the criminal conduct is unlikely to satisfy. That's a relevant factor. Was it 6-7 years ago? Data has shown that once we get past the kind of the 4 to 7 year mark, very very likely that no one's going to reoffend anymore. So we, again, when we look back at like how long should the look back period be on a background check, we shouldn't be going back 30 years. It should be a much more narrow review. And then again, especially in light of criminological research showing that over time, the likelihood that a person with a prior criminal record will engage in additional criminal conduct decreases until it approximates that the likelihood that a person with criminal offense will not commit. So, again, we need to do this assessment looking at all of these factors instead of a blanket ban on housing. And then just a little bit about the individualized assessment of relevant mitigating information beyond that contained in an individual's criminal record is less likely to have a discriminatory effect than a categorical exclusion. So they're saying you should look at the information of the person. So a lot of times in fair housing world or in any discrimination world, we say treat everyone the same. And that's true. But here, we actually do need to conduct an individualized assessment. Individual. What was the alleged conviction for, or the act that they committed? How long ago was it? Evidence of rehabilitation. Same kind of thing we've talked about. And again, the relevant factors here are facts or circumstances surrounding the criminal conduct. Hey, I was 18 years old, or I was an accessory. Evidence that the individual has maintained a good tenant history before and after the conviction or conduct, right? That's important. The age of the individual and evidence of rehabilitation. So this should happen in terms of the assessment when folks are being allegedly shut out of housing for a pass. And I just want to leave one thing before we open it to questions, is that a really interesting case I've been following that the Connecticut Fair Housing Center and the National Housing Law Project have brought against CoreLogic. And basically the issue is this: is they contend that a tenant screening company, CoreLogic, so what they do is that you apply to housing, landlord takes your application, turns it into CoreLogic, and then CoreLogic looks at your background and all of your stuff and gives a thumbs up, thumbs down on whether to rent to this person. So this lawsuit's contending that the company unlawfully discriminated against the Connecticut family when it instructed a landlord to deny a Connecticut mother's request to move her disabled son into her apartment due to a dismissed shopping lift arrest from 2014. Okay, so they're saying, mom is saying, hey, I live here, I want to move in my disabled son. They say, hey, the CoreLogic company said I can't rent to you, so it's a no. And so then the next, and just a little bit about the facts, just so you see how kind of interesting it was. So in 2016, mother submits a rental application to move her son in out of a nursing home. He'd been significantly disabled, was living in a nursing home. And then he was rejected because the CrimSafe, which is one of these database companies that housing providers use, determined that he had an, quote, disqualifying criminal record. And then the son, who was in a nursing home recovering from an accident that left him unable to walk, talk, or care for himself. So again, when we think about this assessment, would this not err on the side of the person should be living there? So these are some of the facts. So then CoreLogic failed to provide the landlord with any documents or explanation of their determination. So they didn't provide any documents. They just said it's a no. And even when the mother requested copies, didn't get it. As a result of the denial, the son had to remain in the nursing home for a year longer than he could have. And then after all of this, the mother later learned that her son's only criminal record was a charge from prior to his accident, and later dropped for shoplifting, an infraction below that of a misdemeanor. So, this is how, one of these issues. And then I kind of asked that, although rental decisions have traditionally been made by housing providers, just the landlord themselves, today many housing providers and landlords contract with these third parties who are making the decisions for them. And then, so for housing providers who use these criminal background checks in their admissions process are going to need to be prepared to show they've done these individualized assessments, as HUD has pointed out. And I kind of asked the question, can an automated criminal background check with computer-generated scores and decisions perform that individualized assessment of criminal history? And I think this is where the future is going with these questions, and that there could be a problem. And I ask again, can tenant screening computers be programmed to apply standard rental admission criteria to criminal records data appearing in the background check? Don't know. Can automated criminal background checks with computer-generated scores and decisions be programmed to evaluate whether an offense bears a meaningful relationship to housing, whether evidence of rehabilitation, maturity, education, or other changed circumstances significantly reduces the likelihood of being repeated, or the other issues that come in with the decision here. So I mean, I think that what I just raised this issue because I think this is like the future. This is how people are applying to housing now, and just to let you know about this case, the main decision that's come out of it is the court did hold that CoreLogic could be liable under the Fair Housing Act, even though they weren't the landlord. That they're covered under the Fair Housing Act. So we have to follow this case and see where it goes. But it really is a first kind of impression of looking at these data companies and how it relates to a discriminatory decision. So I just want to leave it there, and I'm out. So I'll take any time for questions in our remaining time. And again, I really thank you for your participation. And again, I'd love to come out and go around the state and do workshops, do trainings, and connect with everyone. So thank you.
Thank you so much, Branden. This has been extremely informative and helpful, and you're really engaging this entire time, which is a feat. So far we have 2 questions that have come in. If you have additional questions specifically about the housing portion, go ahead and send them our way, but I'll start with the first question, which is, if an individual has a history of being a renter, and I'm assuming they also mean a history of having a criminal record, would it make sense to use past landlords as references?
Well, I mean, I think it could be helpful, right? Because, I mean, let's say, like, as HUD points out in their guidance, you had a good record of being a good renter for many years. That's helpful, right? To show that, well, even though, I was incarcerated, I had a good record before, and, I have a good record now. So it could be helpful in terms of showing that you've had a consistent rental history. What happened before. So it is relevant so yeah.
Great. Someone also asked, are there specific convictions that can automatically disqualify people from being able to rent?
Well, let me say this. On the federal side, there are. With California's proposed regulations, it's a little different. But let me speak to the federal side, and you'll see it in the HUD guidance, which is that under federal law, there are some exceptions. One would be the manufacture of illicit drugs would be something that could be excluded under the federal guidance, right? So they list that out. But I would say stay tuned to what happens in California. And again, we'll probably know soon. But in those proposed regulations, which you can read on our website, it lists out kind of a mechanism of going back and forth, and it doesn't. In the proposed regulations that are not yet law, I just want to keep reiterating that it's not yet the law, there are no exclusions. So it's very broad. But under the federal guidance we've been talking about, and you can check that out on this resources here, from HUD. It's this one here, the Attorney General's, actually, where is it? You have it over here. You can get that there are some exclusions. And so if you just Google HUD, criminal justice, fair housing, you'll see that it's really talking about the manufacture situation.
Great, that's super helpful. And it sounds like once the state regulations come out, we need to have a part 2 of this webinar.
Yeah, they've actually, it's taken several years to get to this point, and I believe they're at the last stop. And I don't have a timeline. Again, it is proposed, but I would tell everyone to check it out on our website. It's a 40-page document. It's towards the end, but it's really inspiring in terms of the thought process that was used in developing it, because it is fairly clear. And if that does become law, it'll be very interesting. But yeah, check it out, and hopefully we can do a part 2 and talk about the new regs when they come out.
That sounds great. No other questions are coming in right now, so I just want to take a moment to say thank you so much.
Oh, it's my pleasure.
Yeah, and I'll send to everyone who's on, and I'll send a link to the recording of this webinar it'll be on YouTube. And if you have questions that come up, like over the weekend or next week as you're thinking about it, feel free to reach out to Branden, reach out to me. We'll make sure that we either answer your question or connect you with someone who can. So thank you again.
Thanks, everyone. Happy Friday the 13th. All right, take care.
Bye.